Well, I'm here with my colleague, Mike Scafidi, and Mike is a 13-year veteran police officer who later went on to become a very renowned criminal defense lawyer, as you are now. And I know that you're an expert on California entrapment laws, Mike. And let me ask you, what is the sort of legal definition of entrapment in California?
It's pretty simple, and I guess the most simplest way to state it is if a police officer or a law enforcement official induces a citizen to commit a crime they wouldn't otherwise commit or want to commit, is sort of the textbook, in fact, it is the textbook legal definition of entrapment, and you learn that in Law School 101, and it stands true today, and there's lots of cases that stand for that proposition.
And what are a couple of just sort of simple examples of overreaching by the police or police conduct that would be construed as entrapment?
Perfect example would be a undercover police officer being told that someone may be dealing drugs, and that officer goes to that person's house and tries to induce them to sell drugs, and no drugs are sold, then comes back another day and asks again, and repeatedly will come back to that person's house over a period of time, ask him to commit a criminal offense. Ultimately, that person, for example, may say, listen, I don't sell drugs, but goes to get some drugs from a friend and just acts as a middleman to give it to the police officer to get them off their property and away from them. That would be a textbook example of an entrapment defense.
So basically, if you're a cop and I'm a citizen and I have no intention of selling drugs, I'm not selling drugs, but you come and convince me to become a drug dealer, the idea comes from you, then that's entrapment.
Correct.
But if I'm already selling drugs and you simply come and ask me to sell to you and I do, then that's not entrapment.
Exactly. In a situation where you are drug selling, and then even if they have to induce you several times over the course of a period of time, you're not going to be able to validly exercise an entrapment defense.
What about, people ask all the time about this scenario where they're talking to an undercover officer. Let's say you're an undercover officer and you're asking me to sell you drugs. And I ask you, well, are you the police? Are you an officer? Are you an undercover? And you say no. Is that entrapment? Are you allowed to say no, that you're not the police even when you are?
That's a great question, Neil, because having been an undercover officer, I was asked that question many times, mostly on prostitution stings. The girls would always ask you, well, you're a cop. No. And the quick answer is this. Police officers do not have to reveal to a person that they're a police officer. In fact, the courts have held that cops can straight out lie about multiple areas. Now, with this caveat, when you're defending someone where a police officer has lied and said they're not a cop, or they've lied about different things to solicit statements, juries don't like that. They don't like people dishonest, and juries don't like dishonest police officers.
There's another scenario that I've been asked about a lot recently, and it comes from prostitutes or people who were accused of being a prostitute. There's an undercover who's pretending to be a John, and they get in the car and the prostitute says, touch my breasts, or touch me in some private place, to prove that you're not a police officer. And the undercover goes ahead and touches her in her breast, touches her in her private parts. Does that constitute entrapment somehow?
Well, you can raise an entrapment argument on that, and ultimately, I guess what constitutes entrapment is ultimately determined by the trier of fact, the jury. I know personally a similar situation where I've represented people where we've had that situation at a massage parlor, and the girls asked, well, you want to touch my leg? You want to massage me also? And the police officer will rub her thigh at the same time to kind of lead them to believe that he's not a police officer. And in those cases, the courts have held that the police officer it's not an entrapment.
Let me ask you, there's a lot of arrests that are being made these days from Craigslist or from AOL or from these sort of online directories where the police will post an ad either looking to buy drugs, illegal drugs, or looking to sell illegal drugs. And sometimes some kind of cover language is used, but that's really what's going on. And it's a setup, it's a sting. Somebody responds to the ad and they meet the undercover somewhere and they either sell them drugs or buy drugs and they get arrested. Is posting an ad like that by the police, that sort of sting operation, is that entrapment or is that permissible?
From a general overview standpoint, it's not entrapment, but I would urge people to look at the facts of that case. For example, let's say some 18-year-old kid sees that ad. He's never dealt drugs in his life. And they say, and he calls up the number, and they say, we'll give you $100,000 for what normally you'd get $5,000. And the kid says, well, wow, I'm going to do that because I need money to pay for my college. And they induce him to commit a crime that he normally wouldn't commit. I think arguably you could bring an entrapment defense, and I think a court would allow you to bring an entrapment defense on those facts.
So basically, if we can show the court, look, our client was not inclined to commit a crime until they saw this ad, and there was some offer that just inspired him to do it, then that potentially could be, we could raise an entrapment argument.
Oh, I agree wholeheartedly with that. In fact, the case that comes to mind, of course, is John DeLorean from years ago, involving trying to fund his failing car company and trying to sell 80 billion pounds of cocaine to an undercover agent. I mean, that's the typical case that you hear about as far as entrapment.
And he was acquitted because of entrapment.
He absolutely was acquitted because of entrapment. And I think in that case, the jury said to the prosecutors and the government that they're not going to put up with that type of government behavior. And I think that's what we try to do now as an attorney, even at a simple level in our local courthouses, take each case by way of entrapment based upon the facts of the case as they apply to our client, and then use them appropriately.
And let me ask you, just finally, Mike, if we have a client who's accused of a crime and we raise an entrapment defense, and the judge agrees, the judge says, yes, I've listened to your arguments, I think that is entrapment, what is the consequence? What happens to the case at that point?
Well, obviously, if we can convince the district attorney that it's a valid defense, it may help facilitate either dismissal outright of the case or a significant reduction in the charges. But ultimately, anytime you have an entrapment defense, that's an affirmative defense. You go before a trier of fact, which of course is our jury. And ultimately, they make a determination as to whether the police entrap someone or not.
And they're instructed that if it was entrapment, then...
They find them not guilty.
And the case is dismissed.
And the case is adjudicated by way of a not guilty plea. I'm Mike Scafidi, a retired police officer and now a criminal defense attorney with Schaus Law Group. If you or a loved one are in trouble and need help, call me.